Well, it's been in the works, quite frankly, behind the scenes quite a while that Blanche was going to come in. He comes from the firm Cadwalader, and that firm, quite frankly, would have a conflict in this case. The firm, Nicholas Gravanti at that firm represented Mr. Weisselberg, who you may see as a witness in the case. But so Blanche has left the firm, is now on his own, and that I suppose was a development because of this being retained in this case. But there was no surprise within the team about that. Well, I'm sure they take it quite seriously. In fact, I know that they do. It's very important for the team to be able to work together now. Yesterday, I saw a concerning article in the New York Law Journal, which it was concerning because Mr. Tacopino welcomed Mr. Blanche to the team. The article said Blanche would be the lead, but then Tacopino texted to the New York Law Journal that you can be sure that when the bell rings, Tacopina, will be handling the major crosses and summations and so on. It's just going to be a process of learning to work together if the team stays as it is. The former president has every right to change his team as he's going along. This is very early in the proceeding. This indictment came, at a time when apparently it wasn't expected. And so it's going to have to evolve, I think. I think there are at least three motions, but I think after the arraignment, they should file a motion to dismiss based on the statute of limitations. It's a very interesting issue, too detailed probably to go into here. And then I think they should file a motion to dismiss and or disqualify Mr. Bragg. It's unprecedented and should be unprecedented from an ethical standpoint to have run for office and campaigned specifically targeting the conviction of a particular American citizen, Donald Trump. One of the things that Mr. Bragg said in his campaign was, whoever has this job, are they going to convict Donald Trump? Convict him. There wasn't an investigation going on at the time, no allegations against him. That's just dead wrong. It shows a conflict of interest, and I think that should be a motion. And finally, I think that they should file a motion to recuse the judge, find out how this judge was assigned to the case. I don't believe in coincidences. This judge was on the Trump Organization case, the Bannon case, and now this case. And there's an historic practice in this district attorney's office, unique among all in the state, for judge shopping through a process of picking a judge to supervise the grand jury and then having that judge preside over the case, a hand-picked judge. They swore about 8 years ago that they had stopped the practice, but I think it needs to be investigated through a motion for recusal. I don't know whether it can be impartial or not. I think it's the appearance of judge shopping that has to be explored. The American public has a great interest in every issue in this case, and everyone wants to make sure that there's a fair trial here. So that's what I think. I think the appearance of partiality or impartiality are key, important factors in a case. Go ahead. It might be that in any case that a party picks a forum. But in this case, with all of the judges in this court, it's remarkable that Judge Merchan sits on this case and those other cases. They're not related cases, and therefore I think it has to be explored. A federal judge said about 8 years ago that if practice is continuing, it may give rise to a federal violation. This practice was challenged in state court, and the lawyers lost who challenged it. But when it went to federal court, a federal judge suggested this may be a constitutional problem. It just has to be investigated.